Hello, I'm Jim Russell. I'm a wealth manager and partner at Merit Financial Advisor Group. In our last session that we had, that I hope you all watched, about estate planning and protecting your assets, we talked about wills and trust, and I told you that we were going to move forward and talk about durable powers of attorney. So remember I said I had good news and I had bad news. The good news was that we're living longer. Yay. Bad news is we're living longer. Yay. Now, when we're living longer, that comes with some problems. Potential dementia, potential incapacity. Somebody may need to handle your affairs for you, particularly your financial affairs, and be able to make legal decisions for you. This is incredibly important. Basically, for example, the state of Georgia says if you have not been given the authority in writing, you don't have it. So you can't just go take care of grandma's problems legally if you don't have a durable power of attorney. Now let's talk about durable. What does that word mean? It means it survives incapacity. Let's talk about what incapacity is. And I'm going to use myself as an example. I'm not incapacitated yet. Could happen, we hope not. But my mother was. She had dementia/Alzheimer's. I had 24-hour care for her in her own home, but somebody had to be able to make the decisions with her banks, with Social Security, taking care of the property, paying the caretakers and so on. I had durable power of attorney. And so when she'd get hospitalized for different things and so on and so forth, I had to have that authority. That was a healthcare directive in Maine. So we'll talk about healthcare directives a little later. At the moment, I want to focus on durable power of attorney for financial matters. So durable, survives incapacity. Now, for example, I've had clients who one of the partners in that marriage, relationship, whatever, became incapacitated. They had to have that durable power of attorney. We had to have it on record because let's say, for example, my client was the husband. Could have been the wife, either one. That person became incapacitated, but that's the person that had the assets and the money. I had to have legal authority in writing in my possession to be able to take care of the financial transactions in order to take care of that particular individual. I hope all that made sense to you. You can certainly feel free to contact myself or any of the other advisors at Merit. Everybody's schooled on this. Let's talk about healthcare directives for a minute. Healthcare directive and medical power of attorney are basically the same thing, okay? In Georgia, they just changed it from healthcare power of attorney, and now the state calls it the Georgia Healthcare Directive. So, if one becomes incapacitated or is even going in for surgery and is going to be out of it for a while, or is injured and sent to a hospital or a care facility of some type or other, one must have a healthcare directive, and what you're doing is you're appointing a trusted person to make decisions on your behalf with the physicians. In this litigious world that we live in right now, meaning lawsuit happy, the physicians are going to want you to have that healthcare directive, because otherwise they're just going to make the decisions per protocol, meaning A, we're doing this, B, we're doing this. You have no authority unless you have these directives. The other part of the healthcare directive is this. In my own case, for example, I do not wish to be put on machines. When my day comes to move to my happy hunting grounds, I do not choose to be on machines, particularly if the physicians, and in the state of Georgia, 2 physicians must concur that I'm not getting out of this alive. Then don't put me on the machines. But if you, and there's many cases, if you do not have those directives in your living will part of your healthcare directive, they're going to do what they have to do. There was a case in Florida years ago, I think her name was Terry Schiavo. The state and the government, a governor of the state of Florida intervened and said she will be put on life support. They had no paper legal documentation to say this is what she wanted. Her family was sitting there, part of her family was saying she did not want to be put on life support. Other parts of her family were going, oh yes, she did. So there was this great argument, the state got involved, she was on life support for months before she died. I don't have very many clients that have chosen that particular direction. So if you want to have choices, you must have these documents. Durable power of attorney, healthcare power of attorney. By the way, the state of Georgia and pretty much other states will appoint a guardian if you don't have durable power of attorney. In my extended family, there's a child that's got issues, mental issues, and they have placed him in hospitals and so on and so forth. He has a guardian. The guardian makes all those decisions. Nothing can happen without that guardian being there to sign off on the decisions that are being made by the state and the county. So I would urge you, have these done. Have them done professionally. Do not go to wills.com or something like that and do it yourself. Not a great idea. If you really want it to work, get it done professionally. We can help you. Thank you for listening. And the next in this series is going to be about long-term care. Thank you for coming back.